To the third case on this morning's docket. That is case number 107768, State of Kansas v. Andrew H. Morris.
May it please the court, Meryl Carver-Ullman, Capital Appellate Defender, on behalf of Andrew Morris. And Chief Justice, if I could have 2 minutes for rebuttal, please.
2 minutes is granted.
I have a lot of heavy burdens to shoulder today, and I definitely admit that, but I don't want to lose sight in this, so I want to get this out first. The crux of this case is that here my mentally handicapped defendant pled guilty to 2 counts of murder based on a promise that nobody in the courtroom had any power to keep. And he did so due to his attorney's incompetence and busy schedule, with a very viable Fifth Amendment issue still on the table. So I know we're under the manifest injustice standard and abuse of discretion layered on top of that. But that's my argument today. That's the nugget of my argument today. So that being said, I'm going to start in with the first part, there were several things raised below. We've kind of limited it in a brief to 3. The first of those is the district court's failure to ask what promises had been made to Andrew to lead him to plead guilty. And I think this is something I don't think I fully realized even until last night when I was looking at the case. This case is actually very similar to Wilkinson, and even more so than I initially realized. First of all, nowhere in the ruling on the motion to withdraw a plea does the court really address the Larned issue. He says, you understood the plea agreement. The plea agreement said that the district court doesn't have to follow, this is just a recommendation, the district court doesn't have to follow it. Nowhere in any of the record, nowhere in any of the testimony, is there anything to show that it was explained to Andrew that even if the district court agreed with the recommendation, which the district court did in this case, I think quite rightly, that was not an enforceable, that DOC could do, within their regulations, of course, whatever the heck they wanted. And over a 40-year sentence, I think it's probably unrealistic to expect that, maybe he wouldn't be at Larned at part of that time. So there's nowhere in the record that I can find anyway that was explained to him. And even the statements that Ms. Chalmers points to at the hearing on the motion to withdraw a plea, and I think it's very contradictory, where he says, I understood that the judge could sentence me to Larned or to state hospital or to prison. I'm paraphrasing, obviously. He never says, and again, it's nowhere in the record, that he understood that even if the judge did sentence him to Larned, that was an unenforceable, essentially, sentence. The judge had no power to do that. No one in the courtroom had the power to do that. And I can't emphasize to this court enough how important that is to my client, because as he said at the motion to withdraw plea hearing, he feels safe at Larned, and he does not feel safe given his mental capacity in other places in the prison system. So to the extent that he pled guilty in exchange for that promise, it was a false promise, and it misled him into pleading guilty.
Was it a possibility? Could the Secretary of Corrections follow the recommendation?
They could. They haven't. And actually, I believe during the pendency of most of the direct appeal, he was actually at Larned, but then he was moved to Lansing, I think, in 2010. And as far as I'm aware, and I presented what I could to the court in a motion on that, that's where he is now, and that's where he...
Where is he now?
He's at Lansing, in the mental health camp there, but he's at Lansing.
What is the evidence of the promise, though? Didn't the written plea agreement use the word recommend?
It did use the word recommend. I think, well, first of all, you're assuming that my client with the IQ of 55 understood that nuance, which I think is a pretty big leap to start with.
But again, where was the promise?
Again, it was in the plea agreement, we will recommend. I mean, again, the technicality of the word recommend, I understand what you're saying there, but I think, again, to someone with with Andrew's intellectual capacity, and he said at the motion to withdraw plea hearing, I understood that the judge, and he uses the word the judge in a couple of places, could sentence me to Larned or he could sentence me to prison. And the judge really actually had no power. I mean, as far as that distinction the judge had no power to make that distinction.
There's really not a promise, it's more just, he just didn't understand. I mean, doesn't that kind of collapse into your, he didn't knowingly enter this plea because he didn't have a full understanding?
It does, and it's also part of the district court's, I mean, because it's, bottom line here, it's the district court's responsibility to make sure that he understood. And I actually grew up in Crawford County, had a chance to work with Judge Nolan a little bit, and think he's a wonderful judge. But in this case, I mean, this plea colloquy was just horrible. Even just a couple of times. Okay, you say you understand that. Repeat that back to me. Tell me what you think it means. Just something. It's almost like a mass, like the call and response. The judge says something and Andrew says, yes, Your Honor. Yes, Your Honor. Yes, Your Honor. There's no further effort to make sure that he understands. And that, under our statutes, is the judge's responsibility, ultimately.
So you think that if the understanding had been better, that there's a real probability that the defendant would have wanted to go to trial?
In this case, absolutely. I have no compunction even saying that. This is a huge deal to my client. If there are no other questions on that part, I'll move on to the second part, which is this motion to suppress that kind of got left on the table is the word choice I've decided to use here. Of course, this is under the ineffective assistance of counsel kind of prong of Edgar and our whole parameters for considering motions to withdraw plea. In this case, it's kind of funny because Judge Nolan and Ms. Chalmers in her brief, everybody keeps saying that this is, there's no way we were ever going to win this Fifth Amendment issue. And maybe I have defense attorney blindness here, but I'm thinking I have a mentally handicapped defendant. The burden's on the state. They questioned him for 6 hours, I believe, used coercive interrogation techniques. I'm thinking, gosh, I would have loved to have gotten this case, even if he had lost it, with that as an issue on appeal. I'll argue that any day of the week. So I don't really understand how, looking at our laws and looking at the Swanigan case in particular, which is cited in the brief, people can look at this and say this was obviously such a losing issue. It was at worst an arguable issue, and at best I think a winnable one. So
do we look at all of that when we have the trial judge's statement that he probably wouldn't have granted that? I mean, how do we factor that into the ineffective assistance of counsel analysis and a Strickland standard that it would have made a different outcome?
That is a really interesting, and it's a hard, because it's, the problem is trying to go back and, look back at this point and figure out what would have happened. And the district court judge is looking at it in hindsight a little bit too, I think. Also, I think, had he gone forward with the motion, again, even if you lose it, maybe he could have appealed it. Maybe, there are all sorts of maybes that could have gone if Mr. Dosh had given himself time to go down that path. And I guess that's part of the problem here is that, and he was very forthright at the motion to withdraw plea hearing. I just got busy. Happens to the best of us, but it doesn't make it less ineffective. And I also wanted to just...
So you're saying that there was no quid pro quo for pleading before the hearing on the suppression?
That doesn't appear in the record to be inherent in the plea offers. In the plea offers, the back and forth is in the record. They had a motions date and they had a plea cutoff date. It didn't appear, there wasn't any, there's no testimony and there's nothing in the letters to say that those were necessarily tied together. They were sort of separate clocks running at the same time. I guess I'll say it that way. I think that the third issue in the brief is basically that just Mr. Morris didn't understand the abstract concept of no contest. And I think that sort of, it plays into all of this. I don't know that I need to spend much time talking about that independently. It's an abstract concept. I think we have plenty of evidence in the record to show that Mr. Morris has trouble understanding those. And again,
it makes a difference. Why? If he thought he was pleading guilty instead of nolo, what difference does it make to the outcome?
Well, I don't know that it does make a difference to the outcome. I mean, again, this is not obviously the strongest issue in the brief. And then as to the cumulative error, which I argued it that way, and now looking at it again, I'm not sure I would have done it the same way. But I think the state is arguing, if I'm right, that because I didn't raise cumulative error below, I can't raise it now. It sort of confuses me because I don't think cumulative error is hardly ever raised below. So I would argue that if that is to be the case, then that's certainly that's news to me. In any event, I think that under 223210 A3, we're looking at this all under a totality of the circumstances sort of rubric anyway, whether the plea was fairly and understandingly made. And so whether you call it cumulative error or whether you call it that, I don't know that really makes technical differences maybe, but I don't know that makes a difference really where the rubber hits the road here.
Any further presentation?
That's all I have.
Any more questions? Thank you, counsel.
Thank you.
State appears by Assistant Solicitor General Natalie Chalmers. There is no reason to allow the withdrawal of plea in this case. There's simply no manifest injustice. There's no evidence of some promise that was made that he relied on. He specifically says that he knew he would go to prison.
What did he get out of this plea?
Well, he got the chance to have, the state recommended concurrent sentences rather than consecutive, so he had that. The judge just didn't follow that.
So he got, for removing the risk of trial, he got a recommendation, unfulfilled recommendation for concurrent sentences.
Yes, and he also got the state and the court agreeing that to tell DOC that he should go to Larned. As for the motion to suppress, there is been no argument that this would actually succeed. I know she made it an oral argument today, but she doesn't have any facts to support that it would actually concede. The motion was filed less than 2 weeks after defense counsel received the expert report that is so heavily relied on in this case regarding why it was or wasn't voluntary. I don't think filing a motion to suppress 2 weeks after you have all the evidence can be considered deficient or in any way ineffective assistance of counsel. But it's his burden here to establish manifest justice. It's his burden to establish error, and by that he would have to show that the motion would have had some kind of success, and if the motion would have had success, that he wouldn't have gone to trial. In fact, he never actually says that he would have gone to trial. The only thing the defendant said was that he wanted to withdraw his plea because he wanted to go to Larned. He doesn't say he wanted to go to trial or that he wouldn't have pled again, which is the requirement in order to have the plea withdrawn in the first place. The understanding of the no contest, the court made a factual finding that he understood what no contest meant, and this court should give deference to that factual finding. As to the cumulative error is raised below a motion to suppress, and in fact, this is the counsel motions. I see it all the time. No, it can't be raised on direct appeal for the first time. I'm not going to say that. But when you are supposed to be giving all the reasons possible the district court should withdraw the plea, you should include cumulative error if that's one of your reasons.
But isn't counsel right that that's the same as a totality of circumstances, which is the test the court should have been applying? So how is that not really raised?
Well, it's not. Cumulative error is not the same as totality of circumstances because cumulative error is not the manifest injustice standard. So I do think that we should just stick to totality of the circumstances and say, do the totality of the circumstances show manifest injustice? I just don't want to use cumulative error, which has a lesser standard than manifest injustice, if that makes any sense. But if the court wants to say in the totality of the circumstances the plea should have been withdrawn because there was manifest justice, I think that's certainly within the court's ability to decide that. But
it does appear from the record that the trial court went through great lengths to determine that the defendant was competent, that he understood the proceeding and understood or tried to explain what no contest meant. and went to great extent to kind of clear that hurdle and to satisfy in his own mind that he knew what he was doing on that day.
Absolutely.
But that's true, but aren't there certain key, once that is accomplished, there are certain key things that were missing from the plea colloquy that's required. That is what the maximum sentence is. I don't see it in there. Was that ever explained?
I'm not sure, since that issue, I don't remember, and since they didn't point out that that wasn't raised, or that that was something to do with the withdrawal of the plea, I just don't remember.
It seems to me that there was a great emphasis
That
on
was in
trying
the
to understand
original.
that he's competent, but
I think it was
It was in the
original
original,
motion.
I believe that's true, but
But not on appeal.
right.
Okay.
okay. But there were certain things that he did to satisfy himself that he was competent, but then skipped over some things that were required to ensure that he understands the consequences of the plea, and that's a pretty significant one, I would think. That just in and of itself, that you understand the maximum penalty that can be imposed, and you understand that it doesn't necessarily include going to the state hospital, and that's something that's outside the court's discretion to, while they can recommend it in all capital letters. But how do you respond to that? That, well, yes, maybe the court satisfied itself, and probably us, that he was competent, but there's certain key things missing.
I do think it is troublesome that it would have been better had the court spelled out explicitly, I'm going to recommend this, but I don't have the authority to order DOC to send you to Larned. That would have been wonderful. But there was a plea agreement, and there's nothing that the defendant is saying that he did not understand that. There's no evidence of that. There's no evidence that the defendant thought, oh, the judge absolutely can send me to Larned. Thus, there's no manifest injustice in this case. And the state would urge you to affirm the district court.
Sounds like you have no further presentation.
I do not.
Any further questions? Thank you, counsel.
Thank you.
You reserve 2 minutes.
First of all, to respond to Ms. Chalmers' comments about the timing of the motion to suppress and how that all happened, I agree that the Hutchinson report wasn't filed until a few weeks before the motion to suppress was filed. However, the date on that same report shows that she evaluated him in October 2007, which was almost 2 years earlier. So my question again then is, where's the follow-up? What's, you've got a trial date coming, you've got this motion, or not motions clock, this plea clock running. Let's do some follow-up before then. And again, Mr. Dosh's response to why he didn't pay more attention to that motion in general, I think, was, I'm too busy, or I was too busy. Also, I think there's plenty of evidence in the record to support the merits of the motion to suppress, although I don't know that we even not necessarily, and it comes back to Justice Lukert's question, I don't know that we necessarily have to prove even that it would have been successful, just that maybe that it would have been filed, but pursued, it was filed, but for Mr. Dosh's busy schedule. And even Ms. Chalmers pointed specifically to the tape in the record, which I don't know if that even exists anymore, which is another perhaps issue with Mr. Dosh, because by not preserving the motion and litigating the motion, some of that evidence gets destroyed. And I actually had not an exhaustive search, but a little bit of a hunt for it, as I've been working on this case since 2009 now, all told. And I'm not 100% certain, I'll put it that way, that even exists anymore, partly due to Mr. Dosh's failure to litigate this motion. Lastly, I just wanted to quickly, something Justice Rosen kind of hit on, and that's this difference between, I think the court's ruling in this case, and I'm stuck with it, is that Mr. Morris is competent. And maybe he is, maybe he isn't, but I'm stuck with it. But
Well, I thought the court did go to great lengths. I mean, you talked about the poor kind of transcript, or the poor interaction, but I thought the court went to great extent to try to explain on the record what happened and determine that he was competent. Plus, he had the competency evaluations.
But I guess that gets to my point, which is the question of competence, I think, and understanding Just because he's competent doesn't mean he understood. And I think
Right.
that those are related but different questions. And I have nothing further. I stand for questions.
Any more questions? Thank you, counsel.
Thank you.
And thank you both for your arguments this morning. Court will take this matter under advisement.